Good morning, everybody. Thanks for joining us. We'll just give it another minute as I see everybody connecting. We're getting good at this. Everybody's leaving themselves muted. I think we've got this figured out now. Letting a couple other people in and then we'll start. All right, looks like we're all connected. Thank you so much for joining us this morning. Incredibly important topic, and we're very appreciative of Fox Rothschild, their team, to discuss this with us. You know, as we start to reopen and bring people back to work, there are a number of questions that surround the becoming vaccinated, what employers are allowed to ask, what we're allowed to do, employees' rights, etc. You know, these are really somewhat confusing times, but also exciting times as we start to see our population become more and more vaccinated. But we are, like I said, we are grateful to have Fox Rothschild with us this morning. Welcome everybody to the session. Just a few housekeeping rules before I introduce Eileen and we begin on today's program. Please keep yourselves muted. Everybody's doing a great job of that so far. We like that. If you have any questions during the session, please put them in the chat box below. Type your question in there. We'll address them at the end of the session and get to as many as possible. We have approximately 60 minutes this morning. So please, even if you have questions in advance, put them in there now, and we will address them at the end. So without further ado, I'd like to introduce Eileen Oakes Musket. Eileen is a managing partner of the Atlantic City firm. She works very closely with the chamber on a lot of our employment questions. She specializes in that. She has a variety of other specializations that she works on, but she has a team with her this morning at Fox Rothschild. So thank you, Eileen, for joining us. I'll turn the floor over to you.
Thanks so much, Michael. That's my pleasure to join everybody today. I hope the next time we can get together, it's in person, but we decided that we were going to do this one via Zoom. And I'm really excited to bring today with me three of my partners, Kathy Barbieri, Ian McClinsky, and Adam Busler. Kathy Barbieri works in this area, particularly has a lot of clients in this Atlantic City region and helps us with some labor and employment and counseling work. Adam Busler is here in our Atlantic City office and also works with us on a variety of employment-related claims. And Ian McClinsky, we've invited today. Ian is working in this area as well, does a lot of work in the greater Atlantic City area and specializes in union-related issues and traditional labor. So Ian's going to be able to provide us with a great perspective on the union aspects of this issue. So let's dive right in. So before we get started, however, I just wanted to let everybody know that it would be great if my screen would go. There we go. We just have this quick disclaimer that we have to put up. This is a presentation that we're providing to you. All the company materials are protected by copyright. I'm not going to read the disclaimer in great detail, but it is important that you understand that you should consult with knowledgeable legal counsel because the applicable laws pertain and it really is going to depend very much on the specific facts and situations as they're presented. So we're giving you general information today, but the answers to your questions might be slightly different depending on your specific facts and the facts you've presented. So vaccine mandates, you've been hearing a lot about them. Are they legal? Yes, they are. But before you jump right in and decide that you're going to mandate vaccines for all of your employees, let's talk about the pros and cons of that and some of the legal considerations. So some of the legal considerations, and we're going to go into these all in a little more detail, is we need to take a very close look at the EEOC guidance that has been issued and also the New Jersey Department of Health guidance. You want to make sure that if you mandate vaccines, that you're complying with all state and local laws, and including the federal laws. And those in particular are the Americans with Disabilities Act, Title VII, and also the New Jersey and other state anti-discrimination laws, depending on whether or not you do business in other states. If you do business in both New Jersey and other states, it does make your situation a little more complicated and difficult than just straight New Jersey employers. So this is really not the first time we've been confronted with this issue. I think that not everyone may recall, but there was a prior pandemic, the H1N1 pandemic. And as a result of that, there was a pandemic preparedness in the workplace and the ADA guidance issued. And we heard from both the EEOC and OSHA with respect to that pandemic. And during that pandemic, we were told that employers could not compel employees to take the vaccine unless they allowed for both medical and religious accommodations. OSHA said employers could mandate the vaccine, except they did carve out a whistleblower type provision for employees that had a reasonable belief that they had a medical condition creating a substantial risk or a serious risk of illness or death. So we're going to turn it over to Adam now, who's going to talk in a little more detail about the EEOC guidance that was issued on May 28th.
Good morning, everyone. The Equal Employment Opportunity Commission has some new guidance that it issued on May 28th, addressing COVID vaccines. And basically the EEOC framed it in terms of looking at other laws, federal laws that would apply in the workplace, such as the ADA's reasonable accommodation provision and the ADA's prohibition against certain medical inquiries. And then Title VII as well, from a religious standpoint. And then there's GINA, which is the Genetic Information Non-Discrimination Act, which prohibits employers from asking about, medical conditions of family members. Next slide, please. So what does the EEOC say? Basically, they just say, there's nothing in no federal laws, particularly the alphabet soup I just named, prevent employers from, requiring all employees to be vaccinated to enter the workplace. So under federal law, yes, you can require your workforce to be vaccinated. However, the EEOC was very clear that if you do so, you must comply with the ADA and Title VII and any other state and local laws that may apply in terms of vaccines and what you can do. So from the federal law perspective, you must show that unvaccinated employees pose direct threat to others in the workplace that cannot be addressed by a reasonable accommodation. If there is no reasonable accommodation that can be found, then employers can exclude the employee from physically entering the workplace. But we're advising employers to be very careful not to automatically terminate a worker who is refusing to be vaccinated or comply with the vaccine mandate. And like everything with the ADA and dealing with things involving disabilities, this is an individualized, interactive process. Everything has to be done on a case-by-case basis, and it's a very fact-specific analysis. With respect to religion, Title VII, that protects employees who have sincerely held religious beliefs from being forced to undergo a vaccination, provided that it legitimately offends their religious beliefs. So similar to the ADA, you also have to look to see if there's reasonable accommodations that could be met, provided they would impose an undue hardship on your business. So for employers who are not vaccinating their employees on site, the EEOC does not prohibit employers from offering incentives or other confirmation or vaccine that being obtained from a third party in the community. So employers can offer small gift cards or offer paid time off to try to incentivize employees to show that they have been vaccinated. But if employers choose to obtain vaccine information from their employees, employers must keep that information confidential under the ADA. So just like employees, when they come to, their your HR people and ask questions or disclose any type of medical information, you have to be sure that that information is kept strictly confidential and shared with only people who actually need to know that information. Now, for employers who are administering vaccines on site, the guidance is slightly different. And what the EEOC is saying is that employers who are administering vaccines to their employees, they may offer incentives as long as they're not considered coercive. And basically, because the vaccinations require employees to answer, pre-vaccine disability-related screening and medical questions, very large, say $500, $1,000 or larger, incentives for the employees to get vaccinated, it might cause them to feel like they're being pressured to disclose this medical information, and employers could run into an issue under the ADA. And lastly, another thing the EEOC is recommending is that employers, what they can do is they can educate their workforce. You could provide your employees and their family members with information regarding the COVID vaccine, raise awareness about its benefits and the efficacy of the vaccine, and then also share information about where and how to get vaccinated. There's a lot of government resources out there that can be shared with employees that tell them where and how to get vaccinated, and about the safety of the vaccines.
Good morning, everyone. So I'm going to talk a little bit about the most recent OSHA guidance. For many of us, this OSHA guidance is very overdue. I think many of us were sort of scrambling in the early days of the pandemic, wishing, frankly, that federal OSHA would have issued at that time some guidelines concerning how to keep employees safe in the workplace. Of course, in the meantime, employers figured it out. But I want to review with you what OSHA has said most recently. On June 10th, OSHA issued essentially requirements for most employers in the healthcare setting. It's an interim final rule that applies to most employers in the healthcare space, but guidance for non-healthcare employees. So I'm going to focus primarily today on the guidance for non-healthcare employees. If you are a healthcare employer, I do recommend that you review the interim final rule. It is quite lengthy. And to Eileen's point earlier today, please ensure that you review it with your counsel to ensure that you're complying with all of the requirements. With respect to the guidance, understand that unless required by federal, state, local, or other laws, rules, or regulations, there's really not a requirement anymore that employers take steps to protect fully vaccinated workers who are not otherwise at risk. So we'll talk in a moment about the most recent New Jersey executive order, talking about how to deal with vaccinated and unvaccinated employees. But for the most part, understand that for your vaccinated employees, the guidelines that I'm going to review in a moment will no longer be required. Next. Employers are encouraged to implement certain measures to protect unvaccinated or otherwise at-risk workers. Some of those things include granting paid time off for employees to get vaccinated. Again, for those employers in the healthcare space, understand that there are other PTO and time off requirements that would apply, for example, to an employee who is suspected of having COVID and for recovery from COVID. So please be aware of that again if you're a healthcare employer. Certainly, again, employers are encouraged to instruct workers who are infected with or have symptoms of COVID-19 to stay at home. Instruct your unvaccinated workers who've had close contact with someone who tested positive for COVID also to stay at home. Continue to implement physical distancing for unvaccinated and otherwise at-risk workers in communal work areas. So while we're no longer required, for example, to keep vaccinated employees behind some of the plexiglass dividers that we've been implementing in the past year, certainly for your unvaccinated workers, you want to ensure that they're continuing to have physical distancing in the workplace. Continue to provide at no cost face coverings for unvaccinated workers. Sometimes people forget their masks. Make sure that you've got something available for them. Continue to educate and train workers on your company COVID-19 policies. Make them accessible both in terms of format and in terms of language. If you have a large portion of your population that speaks Spanish, please ensure that you provide that guidance in Spanish as well as English. Next slide. There's some other things that employers can do to try to ensure that there's not a risk of COVID infection, in particular in what are considered high-risk environments, where the employees are in close or prolonged contact. So stagger break times, for example, in high population workplaces. Try to stagger arrival and departure times. To the extent that you do have shifts, try to really implement a system where you don't have people in a communal space getting, for example, their temperature checked or checking in with security at the same time. Provide visual cues to remind people to maintain physical distance. I think in the past year, we've all come up with inventive ways to notify our employees to stay 6 feet apart, whether it's markers on the floor or something on the wall. Continue to do that for the sake of unvaccinated employees. If you've not done it already, you want to also improve your ventilation. That's a recommendation from OSHA. Continue to properly space unvaccinated or otherwise at-risk workers, in particular those who are in food processing or other types of assembly lines. I'm also thinking of, for example, packaging lines, places where employees are working in very close proximity. Try to continue to space them out as much as possible. Continue to suggest masks for unvaccinated or unknown status customers and visitors. Again, we're going to talk about the New Jersey executive order in a moment that pertains to masking and when it's required and not required. But think about having masks on hand to protect those who are unvaccinated. We all go to the store, we'll go to a CVS, and we're utilizing the payment, the credit card reader. Think about moving that further away from the worker who's actually ringing up your items. Move stocking activities for unvaccinated employees so that they can do that on off-peak or hours when there won't be as many employees around. So again, it's some more of the sort of creative thinking that we've all had to utilize in the last year around the pandemic. That's essentially what OSHA is recommending here for non-healthcare employers. Next slide. We've talked a lot over the past year about whether or not OSHA is actually going to enforce any of the guidance or regulations that it's issued in this space. There has been, most recently on June 15th, citing of an owner of an urgent care. This was an urgent care owner in Rhode Island. He had tested positive for COVID-19. He continued, notwithstanding that positive diagnosis, to interact with his employees in the fall of 2020 after learning that he had tested positive. Ultimately, 6 employees tested positive, and at that time, the urgent care still had not implemented measures to protect its employees. The proposed OSHA fine there is $136,532. Now, while in my experience, OSHA is not going into most workplaces to ensure COVID compliance, we should be prepared that to the extent that there is an exposure at work, an employee may complain to OSHA and raise a concern. And likewise, we should be aware that there is the potential for significant fines in the event that there is COVID exposure at work that was not dealt with through some kind of remedial measures. So if you follow the recommendations that I've reviewed from OSHA, that will give you a good leg up on avoiding an OSHA penalty or other fines. Thank you.
So another aspect of what's been controlling our lives for the last year are executive orders being issued by the governor. And I'm sure everyone has kind of paid attention to Executive Order 242, which came out right before Memorial Day weekend. And that was the one that said, casinos could operate at full capacity. Restaurants no longer have to, space the tables out 6 feet apart. But a couple of days later, the governor also issued Executive Order 243, which really applies to employers. And what it says is that employers that oversee businesses that are not open to the public now can allow employees to enter the work site without a mask. So they've removed the mask mandate for employees who work at places without that are not open to the public. Employers that are not open to the public they're not mandated to require employees to wear face masks or social distance, as provided that the employee provides proof that they were fully vaccinated. And another lesser known element of 243, Executive Order 243, which really applies to employers who have a lot of office employees is that it rescinded a portion of Executive Order 107, which required employees to accommodate remote and teleworking work arrangements and to reduce on-site staff. So that's a big change for obviously for employers who have a large remote workforce. Other pieces of Executive Order 243, it's now employers or businesses can permit customers to enter the business without a mask and without social distancing. However, of course, if the business so chooses, they can require customers to wear a mask to enter the business as well. But the executive order is very clear that no business is permitted to retaliate or discriminate against any employee or who chooses to wear a mask or social distance in the workplace. And switching gears a little bit, for those employers who are considering implementing a mandatory vaccine policy for their workforce, there's a lot of considerations that I think need to be addressed. One is the administration of the vaccine. So, as we know, the Pfizer vaccine and the Moderna vaccine each require 2 doses for them to be fully effective, with slightly different number of days for the spacing out of the 2 doses. Pfizer, says you want to space them out 21 days. Moderna says 28 days. Another thing to consider is the recovery time. The CDC is recommending that that people have 1 to 2 days to recover from the vaccine. So you may want to consider allowing your employees to use obviously PTO for the recovery of obtaining the vaccine. Another consideration is the potential business disruption that a mandatory vaccine policy could have on your workforce. For example, you may have employees who may try to schedule their vaccines during working hours or during their shifts. And employees may also want, like I said before, need time to recover. So these things are all the disruption to your business from requiring employees to be vaccinated is something that needs to be considered. And one way we're recommending employers address that is, implementing a phased implementation. So, prioritizing certain employees who maybe are coming in contact with the public more frequently, letting them go first, or staggering it in a way that maybe allows higher risk groups to get vaccinated first, just so that you don't open the floodgates and let everyone try to get vaccinated all at once, and then you are dealing with your entire workforce needing time off, or otherwise requesting time away from the office.
And I want to pick up on what Adam was talking about time off. So there is PTO available generally for vaccine administration and recovery. Here in New Jersey, employees may use their New Jersey earned sick leave time to obtain their COVID-19 vaccine, to travel to and from appointments, and also for their recovery time. It's really important to take that into consideration, because I know I've been at least getting feedback from a lot of employers about the difficulty they're having in keeping employees, for example, from using earned sick leave or PTO in order to get a COVID vaccine and then tacking it on to some existing family vacation, resulting in them being out for weeks at a time. So remember, certain portions of this leave are protected. So for example, if someone's getting their COVID-19 vaccination, they're going to be eligible for New Jersey earned sick leave and eligible to use that time. And as an employer, you shouldn't be interfering with that time. However, you can always put restrictions on employees' ability to use purely vacation time. So if someone's got a plan to go, on vacation this summer, wants to stack on top of it their vaccination time, give them the vaccination time. But again, you can be more restrictive about their ability to use the purely vacation time on top of the vaccination time. I want to also talk about federal law. Many of you will recall that prior to December 2020, when the law expired, there was the Families First Coronavirus Response Act. For employers of a certain size, they were required to provide leaves of absence to employees in certain instances, and then they had the opportunity to take federal tax credits in order to provide that leave. That leave, as I indicated a moment ago, expired back in December 2020. However, employers still have the ability, if they want, to voluntarily provide paid sick leave or family leave for vaccine administration and recovery. Again, it's an option for employers. It's no longer something that's required at the federal level, but certainly something to think about as you incentivize your employees to become vaccinated, that you may want to sort of dangle that carrot that if you do in fact get vaccinated, we'll provide you with paid leave time up to a certain number of days to run concurrently with your New Jersey earned sick leave time.
Well, first of all, thanks for having us this morning. You know, this slide that talks about union employee considerations can be a daunting one because it tends to be a very highly technical area of federal law. But before I talk about some of the bullet points here on the slide, I want to point out that if you're a unionized employer, just having a union doesn't excuse you from compliance with the myriad of issues that Eileen, Adam, and Kathy have discussed so far. So all the union relationship does is add a layer of somewhat complication to the nature of vaccine policy implementation. So in dealing with unions, whether you're an employer who has a group of employees who have unionized, where a union has become the exclusive bargaining representative of a group of employees, and you either have a collective bargaining agreement in place or not, to the extent that you want to implement a mandatory vaccination policy or even a voluntary vaccination policy, let's say with or without some incentive, as the employer, you have a mandatory bargaining obligation to discuss that decision in the first place with the union. So if you want to have a mandatory vaccination program, you need to sit down and discuss it with the union. If you want to have a voluntary vaccination policy, but have some form of incentive associated with it, it is a mandatory subject of bargaining, and there's two steps to mandatory bargaining. First is what's referred to as decisional bargaining, which you have to sit and bargain with the union over your decision to implement the program. And then to the extent that you move forward with the program or some modification of it, you may have an obligation to bargain over the effects of the decision to implement the policy, and I'll discuss that in a little bit detail in a moment. Some employers try to get around the mandatory bargaining obligation by arguing that their collective bargaining agreement either has language that addresses this subject or has what is referred to as a, commonly referred to as a zipper clause. So let's take this in two steps. It is very rare that you will see a collective bargaining agreement that addresses vaccination. Sometimes you will see it in the healthcare industry, but even in the healthcare industry, it's highly unusual to see that provision in a collective bargaining agreement. What you do see in many collective bargaining agreements is what's referred to as a zipper clause. And it's a provision that in essence says that the parties had an ability to bargain over any issue at the bargaining table. And to the extent that the issue is not covered in the collective bargaining agreement, the employer is free to do what it would like to do. If a union disagrees with that determination, that the zipper clause applies, and here it would be as to vaccinations, the union has two choices. They can file for contractual arbitration, go through the grievance and arbitration provision under the collective bargaining agreement, or they can file what's referred to as an unfair labor practice charge with the National Labor Relations Board, and the government will investigate and make determinations as to whether or not the so-called zipper clause covers the issue or not. I will say that in the context of an unfair labor practice charge at the National Labor Relations Board, the the National Labor Relations Board's case law about zipper clause is very pro-union and anti-employer. So it's very difficult to have a zipper clause that would cover mandatory vaccination policies. So therefore, the default should be to engage in decisional bargaining with the union. Now, what does that really mean? That means you have to give the union an opportunity, a reasonable and fair opportunity, to have a meaningful discussion about the policy that the employer intends or desires to implement. You as the employer would take in whatever concerns the union voices, and then after having those conversations, you do not, and this is where a lot of employers miss the mark, the employer does not need to make accommodations to the union's demands in the context of bargaining, but must take it into account, and then can ultimately, if the parties reach quote unquote impasse, which is a very technical fact-specific analysis, can then implement the policy. But once the policy is implemented, assuming there's no agreement and you reach the impasse, then you also have to, as the employer, have a discussion about the effects of the implementation. So for example, if the employer wants to impose a mandatory vaccination program and the union says no, and the employer moves forward anyhow with the implementation of that policy, there may be individual employees who have a personal objection, not a religious or disability related objection, but a personal objection to vaccination. And they may then lose their job as a result of the implementation of the policy. Under that set of circumstances, the employer would have an obligation to bargain with the union about the effects of that decision process and the implementation of that policy on a given class of employees. So then the discussion may be around, instead of termination, maybe paid or unpaid administrative leave for a period of time, severance, or things along those lines. But the key here is really twofold. One, that even with a union, you have to abide by all of the ADA, Title VII, the executive orders, the CDC mandates, the OSHA mandates, and this is just an overlay to it that kind of complicates the entire process and can delay, ultimately, the implementation of the policy. It doesn't get you off the hook. And then the second thing is to remember that there's a process that you as a unionized employer need to go through to ultimately implement some form of vaccination policy. Next slide, sorry. Practical considerations. So, there's a common theme through all of the comments we've collectively made this morning, and it's about preparation, complying with law, reading the regulations, and understanding what you do and do not need to do. And fundamentally, if you're going to mandate vaccines, one of the key aspects of the mandating policy needs to be some process for employees to request accommodations with respect to disabilities and with respect to seriously held religious beliefs. And that process should not be the individual line employee's direct manager. It should be someone in HR, somebody higher up, so that the decision-making process is not then utilized in the future by the line manager to take potential disciplinary action or be considered in disciplinary action or performance issues going forward. So you need to have, in my view, a more formal process for dealing with reasonable accommodations. And as Adam said, you want to keep these vaccination records separate from the general personnel files. You know, a bunch of our clients who are requiring vaccines, either under a mandatory policy or under a voluntary policy for let's say incentive purposes, get those vaccination cards that, you know, everyone who got vaccinated get, you know, the kind of card you can really probably do on Photoshop and make your own. It's not very complicated. But those records should be kept separate and apart from the employee's personnel file, so that in the future, when a manager goes and takes a look at someone's personnel file to deal with attendance or performance issues, that the vaccination record also doesn't become part of the decision-making process. And the other reason for having this kind of more formal process is you want to implement this on a consistent basis. So you don't want a line manager to say, oh, well, Doug is my friend and doesn't want to get a vaccine, so I'm going to cut him a break. But Sue, you know, is just, you know, a run-of-the-mill worker, and therefore I'm going to make her go get the vaccine and have a disparate treatment claim on the basis of sex. So you want consistency. So, you know, you can require vaccines, but should you? And this is actually the big debate that I think all of us see with our clients. And, you know, the problem with making a vaccine mandatory, especially in the labor market the way it is today, I think you have to take a step back. And while there's a valid justification for mandating vaccines, you have to see the impact of that on your business. So for example, two industries that I've dealt with extensively is the nursing home and home health aid environment, and then the trucking and logistics arena. And employers in those two fields, those two industries who want to implement mandatory vaccine problems have, I would characterize as a problem, a practical problem. So in the nursing home environment, for example, a large number of employees in that industry are employees of color. And in that community, there seems to be a disproportionately high vaccine hesitancy consideration. And therefore, what we've seen is in the nursing home and home health aid environment where employers have mandated the vaccine, the employees have quit and have moved to employers who either don't mandate it or move to the Amazon and other distribution warehouses because they don't want to get the vaccine. And the problem for healthcare related employers is it's very difficult in this labor market to replace those individual employees. And in trucking and logistics is having the same problem. It's very difficult to find drivers with CDL licensing, A or B CDL licensing. It's also difficult more and more to find warehouse distribution center employees. And as a result of that, employers are being hesitant to mandate in the fear of losing employees. So what have they done? They've done these alternatives, which Adam kind of addressed in his comments, which are modest employer incentives, gift cards, cash payments, state park passes, additional paid time off. Now, most of these types of incentives are taxable income to the employees. In that context, one of the issues that has come up periodically is, do you provide the incentive to the employee individually to get the vaccine, or do you structure a program to, in essence, create some peer pressure on employees to get the vaccine? So do you implement a program where there's $100 cash payment to an individual employee if they get the vaccine? Or do you structure a program where every employee who gets vaccinated gets $100 if the participation of employees to be vaccinated, let's say, hits a certain threshold? So I have a few clients who, if there's 70% participation of employees getting vaccinated, the employees who get vaccinated get $100. If it goes to 75% participation, the incentive goes to 250. If it's 80% participation of employees, it's a $500 bonus to all the employees who get vaccinated. So there's some more creative ways of not only incentivizing individual employees, but potentially putting some type of peer pressure on people to get vaccinated. And obviously, employers should do everything that they can to educate their workforce about voluntary vaccination programs. And that may result in bringing in outside healthcare consultants, working with members of the community to incentivize employees through religious groups, to encourage vaccination, even with respect to seriously held religious beliefs. The Pope has come out and said it's, everyone should go get the vaccine. Next slide. So, other considerations, impacts on the impact on employee morale. Are employees going to feel that they're being pressured by the employer? Are they going to rebel? Are people going to walk out? Things like that. And, to some of what Kathy discussed in terms of the OSHA requirements, just getting a vaccine is not necessarily a substitute for creating a safe work environment. These guidance from the EEOC and the regulations just came out. And the week prior, OSHA cited this healthcare employer, the urgent care, for violating the OSHA safety standards, but there was no specific OSHA safety standard in place at the time. OSHA has what's referred to as the general duty clause, where OSHA can basically cite an employer for virtually anything under that rule. So you just have to kind of think sensibly about how you're treating your employees and dealing with the workforce and the workplace more generally. And if an employee refuses and doesn't cite the ADA or Title VII, how do you deal with it? I think you have to be creative. I think you have to take a look at what the people are saying. Yesterday, I had an employee for a client who said, I have a personal belief that it's not safe to take a vaccine, and that's equivalent to a religious belief, and therefore you have to accommodate me. Well, the answer is no. So the question is, what do you do? In that case, we've put that person on a unpaid administrative leave of absence, and we'll see how long that person feels like not earning a paycheck, and hopefully will ultimately come back. And then you really want to, and this goes back to what I said before, disparate treatment exposure. That's why you want to make sure that somebody higher up than the line manager is really doing the analysis here, looking at it, is it a bona fide, seriously held religious belief? Is it a real medical condition? And going through the interactive process to make sure that the employer is properly protected. And employees who refuse, there's fear, misinformation, religious beliefs, medical reasons. The last two, religious reasons and medical reasons, are ones that you have to make accommodations for. But if someone just fears it or is based on misinformation, what we've been encouraging employers to do is educate those employees, try to get them to kind of understand the importance of vaccination in the workplace. But ultimately, you do not need to make accommodation for those first two bullet points.
All right, everybody, so we're just about wrapping up, and one of the last topics we'd like to cover with you is, what are your options to manage vaccine refusal? So I think that Ian and Kathy and Adam have touched on a lot of these different issues already, but you just have to consider the fact that this is, again, the interactive process and different types of accommodations that you'll have to consider. So you're no longer required as Adam had indicated, with that executive order being rescinded, you're not required to allow people to work remotely or telecommute, but would it be an undue hardship for you to do so? Make sure you still have that personal protective equipment available. Again, you want to mandate social distancing protocols if not everyone in your work environment is vaccinated. And even if they are, I know that most of us have been following the news, and some of the new strains, the vaccine is not 100% effective against. They're, we're still up in the 80th percentile, but it's not a complete protection against some of these stronger strains. You could consider separating unvaccinated employees from those that are vaccinated. I'm not talking about creating a leper colony, but you may want to, have some type of work environment where they're separated slightly, or they have some additional protections available to them. And you want to still make sure that you're having increased workplace sanitation. You have, the additional cleaning services, that you have the cleaning products available for people to wipe down their workstations and, common areas if they happen to have been in a conference room. Some of the more extreme measures, which if you do this, you will probably be an outlier, but I have had a few clients, particularly in areas of high risk, they are requiring a daily negative COVID test for the employee to report to work if they've refused to get the vaccine. Know that that is an extreme measure and is not necessarily going to work for everyone. It may not really be an acceptable option for all different types of employers, but in certain work environments, it could be an option. You can also exclude an employee from work under the EEOC's direct threat analysis, but that is an extremely difficult burden for the employer to carry if they do that. And this is the same direct threat analysis that you have probably undergone in the past. I think you see it the most often example that they give is someone who has an employee that has uncontrolled epilepsy, and you need to exclude them from work because they are operating heavy equipment and they would therefore be a direct threat to the other workers. So again, the direct threat analysis is a very extreme example, just like requiring daily negative COVID tests, but we wanted to make sure you saw those options some employers are utilizing. So I think that takes us to the end of our presentation, and we have left some time for questions. I know that there was one question in the chat that maybe, that looked like it was directed towards Ian. I can read that. It says, if a union refuses to allow mandatory vaccination, what direction would you take? And does the union incur any liability at that point?
Okay, so I'll say that this is the typical loaded question. It's not an easy one to respond to because there are a couple of factors that come into play here. One is, what does your union contract say about a number of things? What does it say in the management rights clause about workplace rules? What's the grievance and arbitration provision? What's the no strike provision in the collective bargaining agreement say? It also depends upon the nature of your business and your ability, if you do implement a mandatory vaccine policy, how you're going to handle people who refuse. So it's a little bit more complicated than, giving you a what do you do. I think you also have to balance what the alternatives are and what the union's saying and why they're objecting to a mandatory vaccination program. Most unions would basically say, in my experience, or have said in my experience, we don't want a mandatory program. We want you to do a voluntary program, and we want you to, do some kind of incentive and bonus payment to people. So I'd like to say, implement it and run the risk of implementing it, but without having a full understanding of your workforce, if you implement the policy and an arbitrator through the grievance and arbitration process, or the National Labor Relations Board through an unfair labor practice process, determines that you didn't reach impasse or didn't have the right under the collective bargaining agreement to implement a mandatory policy, and you terminated employees or otherwise suspended employees or disciplined them, you have a potential back pay obligation to those individuals. So I'm a little reticent to answer the question definitively. With respect to the union incurring any liability, that's an interesting question, but the ultimate answer is going to be no. The union has almost no liability for doing almost anything. The system is incredibly stacked against an employer when it comes to labor management relations. In my tainted view, that in part is that the lawyers for the National Labor Relations Board happen to be unionized. So what's good for them is good for your employees, and therefore a lot of the case law supports employee and union rights as opposed to management rights. So it's a very complicated analysis, and I just can't give you a definitive answer.
So here's the next question. OSHA encourages unvaccinated employees to continue to wear a mask in the workplace. In a situation where an employer is not going to mandate vaccines, what is the employer's liability to monitor or track this? And is there guidance on personal employee liability to make that choice? Kathy, did you want to take that one?
Sure. And so as I understand the question, they're asking about whether or not the employer should still be mandating mask usage for employees who are not vaccinated. I would say yes. And I say that because there is still a requirement that the employer ensure the safety of its unvaccinated employees. And really the best and frankly simplest way to do that, in part, is to require mask wearing for those unvaccinated employees. In terms of monitoring that, it's going to be challenging, I think, for example, for your frontline supervisors who may not have access to everybody's vaccination data to know whether or not a certain employee is vaccinated or not and needs to wear a mask or not. I do think, though, that it's an incumbent upon employers to reinforce that mask wearing requirement for their unvaccinated employees, and for human resources to try at least to keep a handle on who should be wearing a mask in the workplace, who's not required to do it, and also to try to really, enforce, frankly, that requirement to wear masks. Again, because what you don't want is, coming back to Ian's comments about OSHA, what you don't want is all of a sudden to have a rash of unvaccinated employees with COVID exposures in the workplace because for whatever reason, they weren't wearing masks, you weren't enforcing mask wearing. That's where it's really going to become, an issue. Obviously, it's an issue that people get sick, but it's also an issue from an OSHA perspective, potentially, to the extent that you've got an outbreak of unvaccinated employees who weren't wearing masks who then get sick.
Okay, the next question is, what is the employer liability if they decide to not differentiate mask mandates between fully vaccinated and unvaccinated employees? If an employer commits to continuing other preventative measures for unvaccinated workers like social distancing, temperature screening, contact tracing, quarantine, vaccine education, etc., what is the liability to lifting the mask for everyone? And this is a non-union employer.
Again, I think it's just a risk from an OSHA perspective. It's not consistent with the CDC's guidelines. Everything that we've heard from the federal government is that unvaccinated individuals should still be wearing masks. And so I do think that you run the risk as an employer, again, if you wind up having employees who are exposed to COVID at work because they're not wearing masks, of potential OSHA findings of violations, but also potentially workers' compensation claims related to the employees contracting COVID-19 at work and because they're not wearing masks. I mean, I understand, of course, the desire to get rid of masks and not have to wear them in the workplace. I'm sitting in my workplace right now without a mask, but I'm fully vaccinated. And so I do think, and I do encourage my employer clients to continue to require mask wearing for their unvaccinated employees. Did you have a different view, Ian? I see you kind of looking at the screen.
So this question and one of the other ones are near and dear to my heart. I mean, first of all, employer liability for employees getting COVID at work is really virtually non-existent. It is virtually impossible to trace an exposure back to the working environment. And in New Jersey in particular, about halfway through the pandemic, a bill was introduced in the New Jersey State Legislature that was designed to protect first responders and quote unquote frontline workers, which included the employee working at Walmart, Target, the supermarket, where the proposed legislation said that if one of those employees becomes ill with COVID, the presumption was they got it at work, and the workers' comp carriers went berserk. That bill ultimately went nowhere because it would basically cripple the workers' compensation system. I think as long as you act reasonably, and when I take a look at all those OSHA guidance bullet points that Kathy went through, the reaction I always have to what OSHA does is duh. I mean, we're all doing all of that, so you had to publish a 900 and some odd page analysis of why the agency is doing this, and then 40 pages of proposed regulations for the healthcare industry, which are all literally common sense, bullet points that most responsible employers are doing. So I just think that as long as you take reasonable steps, you should have zero liability.
Yeah, I agree with that, Ian. And I will say, we're fortunate in New Jersey that law did not pass, the one concerning workers' compensation presumption. It did pass in other states, similar laws, where they do have a presumption that to the extent someone has been working in the workplace and they contract COVID, that there was a workplace infection. So I agree with Ian. I think it's common sense. And part of my advice that I give, common sense includes having unvaccinated folks wear masks, in the workplace.
One of the next questions is a vaccine card considered medical information? We did indicate during the presentation that any information, the vaccine card or information about someone's vaccine status should be kept separate from their personnel file. So you should treat it like you would any other medical information you receive from your employee. Next question, we are a tenant. Do we need to follow the requirements of the landlord? I'm not sure what the requirements are they're referring to. If you're referring to the social distancing requirements or the mask wearing, things like that, Ian, Kathy, Adam, what are your thoughts on that? I think that there is a requirement if you're sharing common space to follow the guidelines from your landlord, but maybe my colleagues join in.
Yeah, if you're a tenant employer, so if you have employees, you may be a tenant of like a building, and you've got employees in your space, you're going to still need to follow the guidance from OSHA, for example, concerning how to keep your employees safe. If you're a healthcare, tenant, then you're going to have to actually follow the interim rule that OSHA issued. So, but if you're simply a tenant, you're an individual who rents, for example, a space, and you're living by yourself, for example, that's not the employer context. And so you're just going to follow the general CDC guidelines like the rest of us.
And the clarification was, does the tenant have to follow the mask mandate if not vaccinated?
Again, if it's an employer and you've got employees who are not vaccinated, I would recommend mask wearing in the workplace. If they're simply a tenant and they're on their own, or it's a residential, situation, then the mask mandate would not apply there.
Another consideration too is it depends what the lease says. Commercial leases often have provisions in there about landlord rules. So to the extent there's something in there in the lease, that might also be controlling.
Good point.
And next question. This is a difficult one because we're all struggling with this. The question is, we moved to remote work during the shutdown, but are asking employees to return to the office. We're getting a lot of hesitation, mostly because of comfort of working from home and not fear of COVID exposure. What are our options? Well, welcome to the club. We're all having this exact same problem, and I think it's because we're all creatures of habit, right? I mean, we all had to adjust to being ripped from our work environments and having to work from home. And then once we get all, we all get comfortable working from home, all of a sudden now it's time to start coming back to the office. And I think that, what I've been recommending to my clients is that to start phasing it in, to give, just to give employees the option of kind of phasing it in over a little bit of time, to be flexible, to take into consideration that there are still a lot of childcare related issues. So if you all of a sudden just say, starting next week, everyone has to be back in the office 5 days a week, that's likely going to cause disparate impact for those who have childcare related issues. So I think that you need to kind of take that into consideration. And what I would recommend is that you talk to your employees about, look, as of September, the Tuesday after Labor Day or 2 weeks after Labor Day, we're all going to be back primarily. And between now and then, we'd like to see you in the office from, as often as you can, understanding that we'll be flexible. And I think that it's really a communication collaboration issue. I think that that's what I've been talking to my clients about, is that really explaining to people that, yes, you can function from home, but are we really functioning and being the best that we can be? Aren't we missing out on that interactive process and that collaboration when we're together in person? And there's a lot of great information out there, a lot of really great articles and studies that show that even before the pandemic, employers that were starting to lean towards allowing their employees to work from home realized that they were missing a lot of that kind of creative interaction. So maybe an educational option, trying to send some of these articles around to employees and talking about how, having you all back in the office together will really maximize your service to your clients and your customers and really make you the best employer that you can be. Do Kathy, Ann, or Adam have anything to add to that?
I think you covered it, Eileen. I mean, I think it's a challenging time, and I think you're right that the way to approach it is to sort of phase it in. And ultimately, I think employers also need to think about whether they want to continue to have some kind of flexible option if it works for their business. Now, not every business can have a flexible option where employees are permitted to work from home at times. I am always concerned about the ability of supervisors, for example, to supervise the work being done. I'm always concerned about the possibility that employees are working and not tracking overtime and subsequently going to take the position they were working, 60 hours a week at home. So you have to be sensitive to some of those potential abuses, but I do think the way to approach it is to educate, to get people ready to come back, phase it in, and then again, hope, fingers crossed, that all the kids are back in school full time in the fall and parents can make the transition more easily.
Yeah, I also think you have to consider the importance of the given employee within the context of your business. So, if you have a great CFO who says, I'm not comfortable coming to the office, anymore or full time, the question is, if you force them to come in and they leave, are you spiting yourself in terms of losing a good employee to another company who may want that person or allow that person to work remotely? So it's a very, I would say almost specific position analysis, that you're going to have to really deal with.
So the last question, and we'll wrap it up. Thanks everyone for sticking with us. The last question is, per OSHA's new guidance, are we required to conduct daily temperature screenings? Are employers covered when we have procedures in place in which supervisors are contacted when an employee has symptoms?
So there is not a current requirement to conduct daily temperature screenings. I think that those temperature screenings have been shown to be largely sort of ineffective. I mean, they will, of course, identify people who have a fever and perhaps have COVID, but there's a lot of people who have COVID and are asymptomatic or have COVID and don't have a fever. So there is no longer a requirement to do that, although you can certainly continue to do that if you want to try to weed out those folks who may have a fever and have COVID. In terms of procedures in place in which supervisors are contacted when an employee has symptoms, my recommendation always is for that gathering of information about whether or not an employee is symptomatic to really be run through human resources, and not to be sharing that information with coworkers necessarily. Now, it could be that a manager has a need to know that an employee who reports to them is out for COVID. But again, I would try to centralize that information with human resources and maintain it on a confidential basis, potentially sharing it with select managers who have a need to know. But it's not information that should be shared just with every supervisor generally. Human resources, like any leave of absence, human resources can tell the supervisor this employee is on a leave of absence. They will do the appropriate contact tracing to the extent that the employee who tests positive had interactions with other coworkers in the workplace. And so really at that point, the supervisor shouldn't be involved with the contact tracing unless, of course, they've had interaction with the employee in question. So centralize it with human resources, make sure they keep it confidential, make sure they do the contact tracing. But in my experience, supervisors don't generally have a need to know the specific details about who has COVID and who doesn't.
And I think that pretty much takes us to the end of the presentation. If any of you out there are employers of essential workers, that there was a bill that was passed that deals with essential workers and workers' compensation related claims. So if you are such an employer, you can feel free to reach out to any of us and we can get you a little more information about that. It was a specific carve out that dealt with essential workers as opposed to just general employees. So I don't think that applies to everyone, but just wanted to throw that out there was a little extra curveball. We've all been managing a lot of curveballs over the last 16 months. I can tell you that it's been a lot of fun. I'm really ready for it to be all done, and so that we can just go back to interpreting regular employment related laws and not have to deal with all of this. But thanks so much everyone for joining us today, and we really appreciate your time.
Eileen, absolutely fantastic presentation from you and your team, Catherine, Adam, and thank you so much for joining us. I have one quick question before we get out of here. As it relates to us, I see a number of people on this call that are on boards and meetings and participate in that. Should we be doing as meetings? They're not employees, but should we be doing screenings for our board meeting? Greater Atlantic City Chamber has 60 board members. Putting them into a room, we're typically pretty close to each other. So as we go back into that environment, should we be doing health screenings of our board members prior to going back into any type of meeting setting? I do an air show meeting where we have 40 people in the room from all over the place.
Yeah, and so we treat that, I think, and my colleagues can chime in, I really treat that as if you're having a vendor or some other visitor come to your office. And so in that circumstance, for example, if you should have a policy in place and a procedure in place about visitors or vendors coming into your office location, and that they have to abide by whatever those policies and procedures are. And for example, that you can't enter our workplace if you have a fever, or if any of those typical health screening questions that you would answer as an employee. We're not necessarily gathering that information from them or asking them to provide us affirmative proof, but we are telling them that this is our policy and we are asking that you not come here if you have any of the symptoms, if you've been exposed, those types of things, that you continue to wear a mask if you're unvaccinated.
Yeah.
Excellent. Thank you so much, Catherine, Adam, Eileen, and everybody that joined us today. Unbelievable amount of information. We will be sending this video back out to everyone. We did record it, but thank you so much for your time, Eileen and your team. Thank you so much for sharing so much incredible information with us. There are certainly some challenges as we bring people back to the office and start working again, but at least we're moving in that direction. The numbers are great, and hopefully they stay that way. So thank you again, everyone, for your time. Greatly appreciate it. And thank you to Fox Rothschild for putting this together.
Thank you, Michael.
Thank you.
Take
Our
care,
pleasure.
everybody. Be well.